Before we even hit the first minute, the judge is already hinting that the citations in the brief might be hallucinated. And if you've been following recent legal disasters, you know exactly what that means: AI-generated fake case law. Let me ask the audience, do you think lawyers should be punished for using AI incorrectly, or should the court show some leniency? Tell me in the comments before we get deeper into this mess.
To look at these cases that were cited, and they appear to be, uh, I hesitate to say hallucinated, but we've all heard, the stories that have been pretty public about, what can happen when you use AI to draft things.
Gillespie, none of the cases made sense. I have a concern, and I feel that as it is my responsibility, I probably will have to share this with the bar. And Ada Molina Costin Cruz versus Darius Nellums.
Yes, Your Honor, this is Luke Kennedy for the defendants.
And Tristan Gillespie for plaintiffs.
Right. So, Mr. Gillespie, when we were reviewing your documents, your your motion, some of the cases weren't making sense.
This is where the judge drops the first major bomb. When a judge says they will have to share this with the bar, that's not a warning, that's a professional earthquake. Question for y'all: if your lawyer submitted fake cases to a judge, would you fire them on the spot? Let me know.
Oh, goodness. I'm happy to review that and fix whatever needs fixing.
All right, Mr. Kennedy, did you have that issue? Because we were trying to...
I did, Your Honor, and that was something that I wanted to bring up today. So it's part of the reason why I didn't file a reply, is because I was starting to look at these cases that were cited, and they appear to be, I hesitate to say hallucinated, but we've all heard, the stories that have been pretty public about, what can happen when you use AI to draft things. And so, for example, Your Honor, on page 2 of the response brief, the Kaplan versus Banks case, I cannot find any case by that name.
And neither could my staff attorney, and she started to question herself. She's fairly new, and I said, no, you've done this before, so let's just ask questions. So, Mr. Gillespie, none of the cases made sense.
Sure, I'm pulling it up right now. Just bear with me 1 sec.
And in all fairness, I'm going to tell you, I looked you up, so I know you practice in several jurisdictions. I'm not sure if this is something from another jurisdiction, and maybe it's their case law, but it's not Georgia.
Yeah, no, I have this as a Georgia Court of Appeals case from 2008.
Right here is where the judge begins pressing Gillespie about the citations, and watch closely, because this back and forth exposes a core rule of legal practice. Heavy checkmark: every case you cite must be real. Heavy checkmark: every quote must be verifiable. Heavy checkmark: and every lawyer is responsible for validating their sources. Using AI is not a defense, it's actually evidence of negligence if the citations are wrong.
The Zoom is sucking the speed out of my computer. Hold on 1 second. I'm trying to actually pull up the case itself. Hold on. So the site I have is Kaplan v. Banks, 289 Georgia Court of Appeals 193. It's an 8 case. Got some quotes from it. Big one is on page 194. The negligence of an insurer in failing to answer a complaint on behalf of its insured does not constitute providential cause or excusable neglect under OCGA 91155B.
All right, Mr. Kennedy, tell me where you had issues, and then maybe I can tell you where I did.
As far as the citations go?
Yeah, because the case law, like I said, I wasn't, some of it just wasn't adding up, or I wasn't able to find the sites that were listed.
So that first one, that Kaplan v. Banks, was the first one that I noted that I just couldn't find either a case by that name, or that citation to the Georgia Court of Appeals went to a different case called Hightower versus Cervantes, which analyzed the timeliness of an appeal and had nothing to do with what it was cited for in the brief. The Rowland versus Say case that 213, it's cited as 213 Georgia App 679. My note on that was that it doesn't talk about anything that was in the Penn site in the brief. It was about abuse of discretion in allowing a defendant to withdraw admissions, and that an occupant of a trailer assumed the risk of injury by walking over a defective floorboard. Nothing about an insurer or agent, not a valid ground to open default.
Here, where things get wild, Kennedy, the opposing attorney, starts listing case after case that simply doesn't exist, doesn't match the citation, or contradicts the argument entirely. It's like watching someone read a grocery list for a store that burned down 10 years ago. Let me know in the comments, is this carelessness or something deeper?
Henderson versus Quadramed Corp case, I actually cited in my brief for, I think, pretty much the opposite of what it was cited for in plaintiff's response brief. Collier versus State Farm Insurance Company, I did find a case by that name, however, not at the site that was listed in the brief. It was not at 248 Georgia App 264. However, the Collier versus State Farm case was just an insurance contract interpretation. It didn't have anything to do with an answer deadline or resetting the clock, as was cited in the brief. And then the last one I noted was Somerville versus Innovated Images LLC, which was cited by plaintiff and has actually been overturned by Bowen versus Savoy, Georgia, which is 308 Georgia 204 in 2020, which was pointed out in my brief. And Your Honor, I would just also say the timing of the filing kind of raised some red flags for me as well. And you can, I'm hesitant, I don't want to cast aspersions, but I've seen this has started to become a pattern where the responses to my motions get filed within an hour or two. And I'll just go ahead and tell you, this isn't before you at the moment, but I did file a motion for summary judgment. In that response brief, I was noticing some of the same things. And I know Mr. Gillespie he's been suspended from practicing in Maryland before. And again, I'm not trying to cast aspersions. I'm just telling you, so he's been suspended in Maryland, and part of that was for lack of
Hold
candor.
on. Where is he?
At this point, the judge is no longer just questioning the brief. She's questioning Gillespie's entire competency as a practicing attorney across multiple states. Practicing in many jurisdictions sounds impressive, but the judge hits him with the truth. It is hard to be excellent when you do that. This is a legal career crossroads moment unfolding in real time.
It appears that he either dropped off the Zoom call or lost internet connection.
I got knocked out. I think I'm using too much of my computer's bandwidth or something right now.
So, Mr.
Please.
Gillespie, I'm a former
Yeah.
staff attorney for 2 Superior Court judges. So, and the staff attorneys I'm privileged to work with are really, really thorough, and we check everything. And so my concerns are that not just that we've had some very well-publicized cases where I guess ChatGPT or whatever the legal version of the AI research and writing platform is, but we've had some issues with that where even judges have been dinged because they've, instead of using good old elbow grease and eye shine, they've resorted to using the platforms. And what concerns me is you're in about 30 different jurisdictions, I swear, between the federal court, 5 different states. I'm a second generation lawyer. I practice in one state because it's easier. You get to know everything. You don't mess up. I had to discourage my uncle, who's a lawyer, from practicing in federal court. I was like, the timing's different. You're old school. You've got to practice where you know and where you can be proficient at all of the rules. And so my issue has always been attorneys need to know the rules of where they practice and be proficient in that. And it's hard to do when you're in 5 different states, 27 jurisdictions in the federal court. So what I'm saying is, just listen to me.
Yep.
you risk a reputation, and as lawyers, that's really all we have is our good name and our reputation, when you are trying to do too much. And so this brief concerns me, because your client is owed a duty of representation, and you owe a duty to be true to the rules of the bar, when you raise your hand and swear the oath. And I just need to know what's going on.
Totally understand. And I don't know how to move forward from this other than happy to provide additional briefing copies of the cited cases. Whatever.
I trust that Mr. Kennedy went to a law school, or if not the same one I went to. I trust that my staff attorney went to a law school, and reading, research, and writing is the first thing you learn. So if two lawyers are telling me that they've had issues, then additional briefing is probably not going to help.
This ending is brutal. The judge openly states she may need to report him to the bar, that sanctions are likely, and that this could lead to serious professional consequences. Imagine being the client watching your lawyer freeze on Zoom while the judge discusses contempt, sanctions, and your attorney's reputation. Final question to the audience: should assisted legal mistakes result in bar discipline, or should lawyers get mandatory training instead?
Understood.
I need some kind of understanding of what we're dealing with.
Okay.